Yeah, exactly. And others were hoping I was, right, Melanie? Ray.
Hey, don't blame me.
I'm holding you fully responsible. Freaking Giants fan.
Before we get into section 5, let's just finish a couple of things about section 4, because I was thinking about it over the last couple of days, and it bothered me a little bit that left some things unresolved when I asked you about, what will you do, what won't you do. When we're trying to set baselines, where you always see a client, blah, 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 blah. As a general matter, right, if you were to set what should you do, you should see your client before you undertake representation, right? And you should fully investigate it with all the paperwork. You should, if you can, talk to witnesses, people who aren't a party to the suit. Hopefully they're obviously going to have a slightly different take on the case. But if we looked at a list of shoulds, they're going to be a lot more than just saying, well, I can, as long as I get some law and some facts, I'm good. The point, as I was thinking about it, anytime you do less than what you set in your mind as these are the shoulds, the preferred route to be done, you need to know that you're in peril because you're not following what you've set yourself as standard operating procedure. Right? Will there be a rare occasion then where you could potentially skip a step, not see a client, or do some of the things? Yeah, but anytime you violate your own procedures that you've established, you should recognize that you're at risk. And that's the point I really wanted to think a little more about. Not must you always, so yeah, will there be an exception to the rule? Sure, times there will be. But the fact is, we end up having to practice law defensively, and you really need to think about your obligation to the profession as well. And so what you really need to do now is set up sort of, well, this is what I'm always going to do, recognizing that you won't always do what you're always supposed to. But when you don't, you need to know that you've got some exposure there. And so you should do so with real trepidation when you violate your own rules. Questions? And I think it's important, I really do think it's important to start to figure out where the boundaries are here, so that, because when you get out there and you have a lot of cases and you're trying to juggle a bunch of things, including your own issues and the like, it's kind of easy to forget what your initial plan was. But you ought to have an initial one and have an initial sort of things I'll never do, things I hope I never do, list. And recognize when you're doing things that you probably shouldn't, because at least you ought to, at the minimum, do them with the understanding that this could be a mistake. And when you have something in your head that says this could be a mistake, obviously you should reassess whether it's worth doing that. And lawyers get into problems because they don't handle their clients' money well, they don't return their clients' phone calls, they don't pay attention to deadlines. And you've all worked too hard in law school to want to have that fall upon you anytime after you leave here. And so that's the thing to start to think about, because where the rubber hits the road, it's not just simply reading a case. You've got someone in front of you begging you to do something, desperately needing your assistance, and maybe sooner rather than later. And that's where problems start to come in. Yeah, go ahead.
Okay. Lawyers in general, I think it's like every lay person sees us as this strong person, powerful person, but at the same time, we are so frail. Why? Because once we make this mistake, it's like our career can just disappear from one mistake that we could have done a proper due diligence investigating a case, or ask for help to someone else that knows more than us and has more experience than us. So,
Well, go ahead, Ray. I don't disagree with either of those. Is that we are seeing as very powerful and hopefully effective figures, but at the same point, you mess up sufficiently badly by mistake, and all of that is removed from you, and frankly should be relatively quickly, depending on what it is that you've done.
Last semester, I took bankruptcy with Jeff Kateyev, and there was one instance where he took the students out on a field trip to the bankruptcy court, and I didn't get to go, but he came back and told the rest of the class that weren't able to go that there were times when he saw clients of other attorneys walking up to him saying, "Do you know this attorney? He's my attorney. I have never seen this person." But they also have their 341 hearing that day. So when you have something like a bankruptcy where you've got to zealously represent and be truthful to the court as well, you're opening yourself up and your client into liability. So I think in that instance, as you said, if you violate your own rules, you're at peril. And it's always that one thing that you overlook or you just neglect to do that's going to come back and
Or you're rushed, or you're busy, or God knows what, but there's a million excuses why you didn't do the right thing. And that's the thing to recognize, is that we don't care why it was when you didn't do it. Every client has the only problem in the world that you should worry about, because that's the nature of clients. Everyone wants their problem solved yesterday. Everyone thinks that they've been overcharged. You've got a million people that can attack what you've done for various reasons, and that doesn't even, we haven't even talked about your adversary and their lawyer and all the rest of it. And so you need to be careful. That's the point. You've got a lot of time invested in this, you've got a lot of money invested in this. Figure out where your boundaries are and be prepared to then be pushed towards them at times, but recognize that there is a line and that you want to be very careful about. And I think a lot of it starts really with, if you are properly prepared and have worked hard, then you know what you need to do. Now you just have to make sure you consistently do it. And if you can't consistently do it on every case, then you need to lighten some of your caseload. Because that's the other thing. Some of you will be dumped in firms where you may have a huge caseload. Huge, right? I mean, when I was in Boston, there were times where I was carrying effectively 100 cases at a time. Now, they all were in various stages of where they were needed to be and the like, and some of them were relatively simple cases. But that's a lot of phone calls in a week. That's a lot of people who need attention. That's a lot of people who expect their case is more important than someone else's. And depending on the firm you're at, it's sometimes hard to get all those in place, especially if you're in court most of the day. Well, when do you return those calls? When do you send those letters out? And that's the thing you need to think about and focus a little bit on. Because practicing law, you have a lot of power, you also have a lot of responsibility. And we expect a pretty high level of performance from people who get to have that. And that's the thing to think about. And to make sure that you understand where the boundaries are and what you're prepared to do. And most importantly, you prepare every case as if it could be a disaster. I've seen lawyers not prepare a case fully, thinking it's going to settle. Well, if that's the way you go into it, then I'm going to exact my pound of flesh on the back end of this, because I know you're probably not ready to try it, and my number is going to go higher. I've seen lawyers just sort of play around with the case through discovery, expecting that sooner or later this will all resolve, or that the client will settle for less than what they might, and now they've got an angry client because the client was expecting they were going to get what you promised them at the outset. Don't promise what you can't deliver, and deliver what you tell them you're going to do. Yep.
Regarding what you spoke about in the last class regarding filing on time and not missing statute of limitations deadlines.
Yeah, that's like a given, right?
Yeah, right.
Okay. I mean, like right? That's not even close. And so you better have a system designed to make sure that that doesn't become an issue, because you don't have any basis to say, oops, right? I mean, that's like, I didn't return your call this week. I was tied up in trial. Talk to you the first of the week. Okay. I missed your statute of limitations because, no, but go ahead.
But let's say you have an instance where, missing the statute of
There is
limitations.
no instance.
Well, let's say a client comes to you and says, I have this problem, but, the SOL runs tomorrow.
Goodbye. You're not a client. And then seriously, you need to understand this as well. If it blows up on your watch, it blew up on your watch, right? I had the situation. A woman came in to me when my office was in Boston. Old enough. She was raped on Boston Common. Didn't get appropriate attention. Sound like there should have been Number of different parties potentially liable. The more I talked, it was 3 years ago. The case had been shopped around among lawyers, and time was going to run out probably in less than the next month. And I felt very sympathetic, and I felt very, very bad, and I thought that this could be some big numbers if the case could work out right. Goodbye, right? I'm sorry, goodbye. And then, frankly, if you want to be safe, you've got to send a letter saying, if you do intend to proceed, you must proceed quite quickly, because it appears your statute of limitations will expire shortly, because otherwise, if you know, it's what's the one with the chair or the hot potato, right? You walk around the ring, whatever the hell that's called. What's the one at the birthday party you do? Huh? Musical chairs. If you're the last one left, okay. So that's the point, and this becomes a problem for younger attorneys, okay? Because listen, this last one, not to digress again, this not this discrimination case, but the last one, which was a big one. They filed suit on the 300th day, and the way discrimination claims happen, you don't have years like you all sort of, 2, 3, 4, and we've talked about statute of limitations. Discrimination claims, we're talking days. Now it happens to be 300 days, but that's still days, not years, okay? The suit was actually filed on, not the suit, the claim with the NCAD was filed on the 300th day. Big claim, big claim. I didn't file it, I was brought in afterwards, okay? The whole summary judgment motion really, for the most part, dealt with whether it was filed timely or not, which really means whether he filed timely on behalf of the plaintiff in what ultimately was a big suit. So if he messed up, that's on him, that's on you. And so that's the other part of this is, especially for early on, you guys have to know, that's why you do research before a client comes in. You need to know, what are we looking at for potential limitations periods? And unfortunately, a lot of people don't think of it in periods of days. You think, I got a couple of years or two. But that's even more important why your receptionist has to be prepared to screen calls. Because there's some people you don't even want to bring into the office, right? And you need to recognize that. If it's that close, listen, I wish I could help everyone. You can't. Let someone else have their hands on it when that blows up. And that's vital to recognize early on. I think it's harder to recognize early on because you need to start to think about what the case is that someone's bringing you, and is it worth even touching? And so it absolutely, and trust me, it absolutely comes up where, for whatever reason, and usually if the case has been shopped around, is my experience, meaning they've asked various attorneys what their advice is, and now they finally decide to settle in. Well, that A, that should tell you something. B, if you're too close to that statute of limitations, trust me, you might save it. You might. But if you don't, it's on you, right? And that you got to recognize. I had a guy one time who wanted me to do a zoning appeal. You have 20 days from the time of the decision to file that appeal, or it's untimely. And so, and you see, you got to recognize that. So now we're talking less than 3 weeks, or you've messed up again. And so, tells me on Thursday he wants me to do it. I said, that means I'm going to be working all weekend, and that means you're going to pay me to work all weekend, and you're going to have to bring a check in on Thursday for a fairly large amount. Whether you file or not, I'm going to have to spend that money because I'm working all weekend to get this thing ready. No, absolutely. I've decided, because I talked to them at the beginning of the week and sat down and over it. No, I really want to go forward, really want to go forward. So I worked all day Friday, all day Saturday. I didn't do Sunday. I got in early Monday to finish it. It was all set. I said, I just need your signature on it. I wanted to have them swear to it. I wanted to have a juror in on it, not just my signature based on some of the stuff that was going on. He comes in Monday at 3, so we could file it by 4. He says, Mike, I changed my mind. I said, you're kidding. I mean, it's not your money because my check's already been in the bank and it's spent. I said, you realize the money is gone at this point already, but if we do not file in the next hour, you are out. And he said, I said, so there's not any more time to think about it. Do you want to file it or not? He said, no, I've just changed my mind. I'm really not interested. And he spent I think it was $500 or $7,500 in a period of a weekend's time for work that they've never used. But you had to do it, because he said he wanted to go forward, you had already represented him, and if you don't do it, and 4 o'clock comes on Monday, then you've blown the statute of limitations. And so, that's not something that's acceptable. I mean, there are some things like that you just have to recognize. There's no excuse, really. Well, I didn't know what it was. You're a lawyer now, right? You have to know what it was. I thought I had another year. Well, that means you were wrong on the law, and that's what you're paid to interpret. So it becomes, that's an easy malpractice, right? Easy. There's much harder things when we say you're closer to the line. But missing a statute of limitations, missing a filing deadline, that's pretty easy. Okay? Questions on that? Listen, it's not as scary as you all look right now, okay? But the sermon is supposed to be about making sure we're not in that area, and that is what is really important, because it's easy to let those files sit on the side of your desk and say, oh, it's a dog shit case anyway, I'll get to it when I get to it. But trust me, months can go by, and then that case is still sitting there. You got to do something with it sooner or later. And what I've learned in a bunch of experience is just don't take it. To the extent you can, I think there's a tendency early on, you have more time on your hands, you want to help everyone, you certainly want to make some money if you can, and so there's a tendency not to let anything go away. In the long run, you are far better off taking fewer cases and making it a more profitable practice than trying to help everyone, especially the ones that are likely more problematic to win. And that may sound cynical and harsh, but that's in your own interest to start to think about that.
Well, let's say a person wasn't screened properly or at all.
Say a person wasn't what?
Screened properly
Yeah.
or at all. So you really
dead.
don't know, you only know this person was raped, let's say.
Yeah.
You know, and they want to talk to, and they didn't want to talk to the secretary about it, or even you about it over the phone at length. So they want to come in and meet you. At what point are you bound to represent that person?
I'm not bound to represent you at all, and you're probably not going to get in.
But if you come in, if you let that person in because you want to know, you're a new attorney, you know,
But
you're
you could have
busy,
a
but
no,
let's
wait a minute,
say-
you could have a conflict. You could have other problems that you shouldn't be getting access to this information anyway, right? And listen, sometimes that happens. They don't want to talk to the receptionist or your assistant. Okay, I'll call them myself, and I'll explain to them why. Okay, listen, she or he cannot schedule an appointment for you until I at least know more. Period. So tell me, and it'll stay confidential between us. But I need to know, for instance, for one of the things, when did this happen? And if you tell me it's 4 years ago, really, sorry, my caseload's full. I really can't help you. You may well have a problem at this point. At any rate, we had my caseload now is 1 or 2 cases, so I really handle most of all of that myself as to who I will see. But in Boston, the receptionist had various checklists of information that she was required to take before an appointment could be scheduled. Because one of the things you must do is make sure it doesn't conflict with any of your existing clients and the like. Because otherwise you could end up, suppose you have some big clients, suppose you represented hotels or someone like that or other large entities. You might get information then that not necessarily disqualify you from representing that person, but lose the bigger client as a result of it because of the issues that were raised in the conference, or at least temporarily not have access. That's more problematic, and you need to screen that out beforehand. You also need to screen out, in all honesty, you got to screen out some of the loonies, right? No, really, right? Let's be realistic. You get a lot of calls. Go ahead.
I just had a question. If they're past the statute of limitations, do you still not tell them you're past the statute of limitations? Or?
Well, here's the interesting thing I've found in my experience is I think you've got to be careful with that, because unless I get even more information, maybe there is a contract claim that you can make, right? So maybe it's not just torts for 3. Maybe there's contracts for 6. Maybe even there's some other statutory remedies without doing the research that you might still have time on. But frankly, I don't want to touch it. And I don't want to do all this research and have you waiting. That's the other thing. well, and sometimes we do this, right? I'll look into it and I'll get back to you within a week or two. Well, what if the damn clock is ticking, right? So that's why you've got to be especially sensitive to the statute of limitations issue. And that's the problem, but even still, sometimes, unless you do a fair amount of research, tort and contract claims a lot of times will overlap a little bit. Sometimes they're more clearly torts and it's relatively easy. But you buy a product or you look at some of these others and it could be a mix of both. Suppose the rape happens in a hotel. Is that just a tort? I don't think so. I think there's some contract between me and the hotel that you're going to have a security staff present and the hallways monitored for this type of activity. So maybe, the tort's gone, but the contract exists. I still wonder where the case has been for 3 years. And that should raise a red flag. But that's the problem is, it's easy to say here, well, it's cut and dry. Well, look at the employment agreement cases, right? So someone comes in, they say, I'll take this one from last year. Says he was falsely imprisoned, intentional infliction of emotional distress, handicap discrimination. I got 3, I'm still missing 3. A breach of contract, employment contract, but there was no contract, so breach of implied contract for work, which isn't that swell. I'm missing one. I forget what the hell the other one was. Now those claims, there's a variety of federal and state issues with respect to those claims. There's also a legitimate argument that some of those claims are covered by workers' compensation, which means they can't go to court at all. So when you look at those claims, there's all variety of different statute of limitations involved in those various claims. Now, as long as you get it early, you can sort it all out. But if that claim had stayed around a while, you'd start to be worried. And as it turns out, as I told you, that's the one that it wasn't filed to the 300th day. And any defendant is going to argue that you are at that point, even assuming you filed on the 300th day, that your damages are limited to that occurring within those 300 previous days. And it made the case more challenging, certainly, because now the entire, at least as they saw it, the entire employment period focused on the single day, the last day, where we were arguing he was constructively discharged. And again, you're not just defending your client, or you're now defending choices sometimes you made. This was not a choice I made, but sometimes choices you or your co-counsel made. And that's not a good situation to be in.
No, I didn't have my hand.
Oh, was it Freddie? One of you guys had your hand up? No?
No.
Okay. Anything else on this before we look at our cases and stuff? Because we got other stuff to do. Ready? We're supposed to look today at Rules 52 and Rule 58. 2 interesting rules. Rule 52, findings by the court. First of all, this refers to findings of fact and conclusions of law. In a non-jury trial, judges are required to enter findings of fact and conclusions of law. You, as the lawyer, are required to submit, generally, findings of fact and conclusions of law to the court. Good lawyers submit proposed findings of fact and conclusions of law. Many judges will require you to submit. So for instance, if you tried a probate court case, divorce case, you're going to submit findings of fact and conclusions of law. Findings of fact simply are the facts as established by the evidence in the testimony. But from the work standpoint, what that requires you to do is go through the evidence introduced at trial, the testimony introduced at trial, and put in page and line references to that information. So it's a pretty cumbersome project. But what that means is then the court can look to see where that information is in the record and where those facts were established by way of the trial. At that point, then one can see if there is a legitimate evidentiary basis for the findings that the court made, and that these are the findings. Oftentimes, they're the findings you asked the court to make based on what you say the evidence was and your interpretation of the evidence. Conclusions of law simply are what the law then the correct law that applies to that case. For instance, if we were to try a jury trial, the court instructs the jury as to what the law is so that they can arrive at their decision. And you would have, in all likelihood, submitted proposed jury instructions. Under Rule 52, the rulings of law are the law that you tell the court, this is dispositive of this case. And what it allows us to do then is to look at those findings of fact and conclusions of law and determine whether the court's judgment is appropriate. More importantly, it allows the appeals court to look at those findings of fact and conclusions of law to determine if they're appropriate. So we're going to see in various cases that we read here, Pier 4 was one of them, where the court made detailed and extensive findings of fact and conclusions of law. On an injunction, when the court determines whether injunctive relief is appropriate, they are supposed to make findings of fact and conclusions of law that support the court's ruling. And that's the way that process is supposed to work. And Rule 52 ensures that we can look at the judgment and see what it is based on in order to determine whether the matter was correctly resolved. Oftentimes these days, the court is going to require you to submit proposed findings of fact and conclusions of law, which then means that it's going to be likely sometime after the trial, because you need the record of the trial in order to generally submit those requests for findings of fact and conclusions of law. It's another reason, by the way, why you may have to make arrangements to have a stenographer present in a case you expect to be problematic, because that's the only way you're going to have references to the testimony, the stenographic record, to be able to make those findings of fact and conclusions of law. Any questions on how that works? Then take a quick look at Rule 58. Rule 58 is an interesting rule. It's really sort of a rule that, for the most part, is overlooked, and it really isn't that important in the sequence unless it's overlooked. But Rule 58 simply requires that every judgment be set out on a separate document in order for that then to be entered in the court's docket. So it allows both the papers and the docket to indicate what the judgment of the court was, and it becomes important at times as well for the purposes of running the appeal and the like. So Rule 58 just simply establishes the requirement that the court, by way of a separate document, issue its judgment so that it can be properly recorded and so that the parties are aware of what it is. It also then helps to know what the how much time you have then from that time to pull your appeal. Questions on that? You know, that one sounds like that's really, and only in practice that sometimes becomes important when the court, you know, issues an order, but then doesn't issues an order verbally, but doesn't issue the order by way of a separate document. That you then sometimes have to go back in and make sure the court actually does that, because that becomes important for the purposes of both enforcement as well as running the appeal. Campbell Soup versus Giles is our next case, and this section really asks you to focus a little bit on the actual procedure involved in how injunctions issue. And we've talked about it from time to time, but I do think it's important for you guys to start to see it, because I think in a civil practice, you oftentimes will either be seeking injunctive relief, in many cases, will be seeking injunctive relief or opposing them. And it is very important to understand how it works, because in my experience, whether you get the injunctive relief or whether you're successful in opposing it may well mean whether that case is going to settle relatively shortly after that, simply because if in fact it potentially changes the dynamics of who has the superior position, depending on what happens at that very, very early stage hearing. So Giles leaves Campbell Soup Company, and again, this is one of these areas where we do see injunctions sought and opposed quite often, is when we have employees leaving one company to go to work for another, and both from a standpoint of not wanting the employee to take business or trade secrets with him, but also as simply as a means of gaining a business advantage, either by stealing someone else's employee or then stopping the employee from working for someone else. Very, very common, and very oftentimes companies will spend money on this. And sometimes I think it's done simply to try and gain in leverage, because the employee himself probably doesn't have a lot of money to be able to fight some of these big companies as well. So here, his principal complaint, it says, is that the court failed to conduct an evidentiary hearing prior to, I think they denied, right? They denied their request for preliminary injunctive relief, finding that Campbell had satisfied none of the 4 criteria. They call it 4, you know I call it 5. They're assuming that the argument of no adequate remedy at law was already satisfied. So they sue Giles, and it says that Campbell filed this diversity action against Giles shortly after Giles left to go work for PET, right, Progressive. And he advanced a series of counterclaims, including one for intentional interference with contractual relations. So what's a diversity case?
That's a relatively softball.
What's a diversity case? Go ahead.
Diversity case is when neither the plaintiff or the defendants are from the same state, and the case is heard in federal court. You can't have.
And?
I'm sorry?
And?
And $75,000 has to be the amount. It has to be $75,000 or more in damages.
Is that what, that's the language?
I'm sorry?
Is that the language?
Reasonably likely.
Reasonably likely to exceed $75,000, right? No plaintiff's stake can be the same as any defendant, and the claim must be reasonably likely to exceed $75,000. And obviously these parties are from different states. There's really not a suggestion that it might be less. It also says he then filed a series of counterclaims, including one for intentional interference with contractual relationships. The best defense is a good offense, right? And that really is true. A counterclaim is a claim a defendant has against a plaintiff, right? And you know there are 2 types. What are the names? Permissive and compulsory, right? Permissive doesn't have to be brought in response to the principal claim, but a compulsory one does. A compulsory one arises from the same set of facts and circumstances as the principal claim. Permissive one doesn't. A permissive one, though, will need a separate basis for federal court jurisdiction in this case, so we assume that these are all compulsory counterclaims, which I think they are, because they all arise from the same transaction or occurrence, which is Giles' employment with Campbell Soup Company. So he's working on this super secret soup project, right? Did you know there was a soup season? That's what it says, right? Since the peak of the soup season ended in March or April. There you go. So see, you didn't even know there was a soup season, but there is. You sort of figured there was, right?
Makes sense.
You don't drink soup in July?
No.
Does make sense. Why shouldn't Campbell Soup get their injunction? And what's the process for if they do want it? How does that work? Because it says here the court declined to grant the TRO, and then denied Campbell's motion for a PI as well. So what's our test? No adequate remedy at law will put it aside, saying they say no, money damages won't make them whole, but then the court goes through the balance of the test. Likelihood of success in the merits, immediate irreparable harm or injury, balance the harms to the competing parties, what if any public policy considerations are there. So why does the court feel that Campbell isn't likely to succeed on their request to enjoin Giles from working for PET and disclosing any of their confidential information? Go ahead.
One, because he was, it was already past the marketing season, and he wouldn't have been able to give any information, and even if he did, it wouldn't have been like they would have been able to do anything with the information. And also, he was in place to implement the marketing strategy that Progressive already had. So he wasn't in the strategy portion of the marketing plan. So they weren't likely to win on the merit because, even if he did get the secret, there's nothing they could do with it.
Well, what about that? Well, what about, how is that determined then, though? How is it determined whether the five-part test is satisfied or not, and what the facts are? I mean, Campbell says, okay, let's put aside the actual merits of the case at this point. Shouldn't we get an evidentiary hearing on this case? And by evidentiary hearing, you should know what that means. That means I get to call witnesses, I get to cross-examine those witnesses, I get to offer evidence and challenge evidence. I mean, just like a hearing that we would see at a trial, if the court is going to grant or deny injunctive relief, Campbell is saying, I would like a hearing to see whether the five-part test is satisfied. And yes, I understand that there's some issue about what's a trade secret and whether it was still confidential. And they do talk about, it was the public disclosure of the information. Do they get an evidentiary hearing? Because I think I would like that. I think it's very easy for someone to write an affidavit, sign it under the pains and penalties of perjury, to send to file a memo with it and say you're suffering immediate irreparable injury and that he's got confidential information and trade secrets. I think it's easy to say that on paper. I wonder to what extent some of those types of things will stand up to cross-examination. And I think specifically what they would like, Campbell's would like, is I want to crack at this guy. I want to put him on the stand. I want to see what specific information he's given to them. And I want to make a determination whether he's using information that we gave him, proprietary information, in an improper manner. By the way, why do you think they didn't sue Progresso here as well? Because it just says Giles. Go ahead, John.
Because the Progresso would have more money to defend.
Damn right, right? So I'm this poor guy who left Campbell's. I want to go work. I've got a job. And now I've got to defend myself against Deckard, Price, and Rhodes for Campbell Soup. And Campbell Soup, who have lots of money. Actually, he's got Warner and Stackpole with him, so he wasn't crying either. Someone was paying for Warner and Stackpole, trust me. But what about that? Would you do that? I mean, is that part of your analysis as well, who my parties are? Depends on how badly do I want to win? I mean, because you name Progresso here, you've got a different case, don't you? So you're just going to beat up on the little guy? Is that the plan? That's what it takes? You're smiling at over there? No, because that is a strategic decision you made, isn't it? Everyone's good with that?
Could you go after him, and then if you wouldn't go after the company?
You potentially, yes, because they've obviously induced him to breach whatever the agreement was with you. Yeah, well, so we'll pick them off one at a time. Maybe even collateral estoppel is where you're going there, right? Well, why not? Why not? There does seem to be something unfair about that, or that's not unfair at all. We don't pick the biggest, most well-heeled defendant necessarily. We choose to fight the battles that we think we can win. I don't have to make it fair to Giles. I want to prevent him from working for them. I want to disrupt what they're doing over there. I'm going to sue him. And by the way, I might not even have a claim against them necessarily. Was he subject to some form of employment agreement, like a contract?
Yeah.
He was?
There was just no non-competition agreement portion in the contract.
Right. So he had some agreement about keeping
Trade or something.
right,
Trade
keeping
secrets.
use, divulge, or publish any of the company's trade secrets.
Yeah.
But there was no non-compete. It was never signed. And so he's supposed to keep things private, but if they really wanted to protect some of this, they should have done a better job themselves as well. Well, what do you think about their argument that they should have gotten, now this is the First Circuit, which is where we are, by the way. You're going to see a variation among circuits with how they treat requests for injunctive relief. And this is really important, again, because of how important the decision on injunctive relief is. So the First Circuit, should they have gotten a evidentiary hearing or no? And does Campbell's get an evidentiary hearing? It says a full evidentiary hearing conducted in open court. Do they get that? Not the First Circuit, they do not. Are there any circumstances under which they would have a better argument that they should be getting a full evidentiary hearing? Or is the answer just no? No, never. Never? I don't think, never say never, no. Under what circumstances might I get a full evidentiary hearing? Fred?
Unless the court abuses discretion by denying.
Well, but how the court abusing its discretion by denying it is going to be somewhere, decided somewhere on appeal. I'm looking for language I might be able to use to convince the court that they must schedule that evidentiary hearing, because I'm looking at this case, and all it says is, and this is on note for Roman numeral 2, page 470 of the original decision. All it says is the court must offer the parties a reasonable opportunity to put forth and to oppose the disputed evidence. And then it goes on to say, over the course of 18 days, Campbell submitted an abundance of materials, a verified complaint. What's a verified complaint?
Signed by the,
Say what?
signed by the client.
Just signed?
It's sworn under the.
Signed under the pains and penalties of perjury. Rule 65 requires either the party move by way of a verified complaint or affidavits with the motion. Verified complaint is just the jurat on the bottom of the complaint that says, I, Michael Coyne, being duly sworn, depose and stated my own knowledge that the facts listed above are based on my personal knowledge, except such facts are listed upon information and belief, and those of which I believe to be true. What it says is that I've read the complaint, I understand it, not just the lawyer now, the person, because you don't have personal knowledge of any of that. The person who is the plaintiff, or someone who has personal knowledge of those facts, has now done it. So they filed a verified complaint, 3 initial affidavits, 7 reply affidavits, a memo, 4 letter briefs, excerpts from the treaties, and copies of pertinent case law. I mean, they filed a lot of paper. The court also twice entertained oral argument on the ex parte application, and then nearly an hour-long session attended by both parties. But they didn't swear one witness in, and not one witness was examined by direct or cross-examination. This was enough, right? The court heard them by way of their briefs and their submissions. I want to know when I get a evidentiary hearing, because that's the stuff I like. When can I get that? Is there any circumstances? I'm looking at, I think it's Roman numeral 2.3. No, I'm sorry, it's Roman numeral 2, Arabic 2.3, page 470. At least again in my book, 470. You're looking at Roman numeral 2 if you've got different pagination. It says here, there's language here. The earlier part says, we have indicated that the balancing between speed and practicality versus accuracy and fairness should be entrusted to the district court's discretion, right? That the court should have some latitude in how that is conducted, and that court should exercise that discretion. But then it goes on to say, to be sure, when the parties' competing versions of the pertinent factual events are in sharp dispute, such that the propriety of injunctive relief hinges on determinations of credibility, the inappropriateness of proceeding on affidavits alone attains its maximum. Well, think about that, right? So if I want an evidentiary hearing, I have to argue that the facts are in sharp dispute, and in this case turns on the credibility of the witnesses who have filed the affidavits. Under those circumstances, Your Honor, I think we are entitled, not I think, we are entitled to the evidentiary hearing, and we want to examine the witnesses in court under oath, especially because this case turns on their credibility. That's the argument you have to make if you want an evidentiary hearing. And that's the argument you should be prepared to make. You know, because you have to remember how an affidavit is written. Who writes the affidavit? The lawyer, right? And so if I got to write my own testimony, and sometimes you do in administrative cases and the like, some lawyers will take certain leeways with that. I imagine you would. Is there anything wrong with that, by the way? I'm just saying, I'll use the phrase I use is coloring the facts, right? We're certainly not falsifying evidence, and certainly not telling untruths. But you color the facts to assist you, don't you? Isn't that what you do when you present an argument? You color them, right? You don't lie, but you put the slant on them that favors you. We all in agreement on that, or you looking cautious? Which is okay if you're cautious, but you're an advocate, right? And so you don't lie. We've already decided that, but you're going to slant the facts that tip in your favor, aren't you? Stephanie, you look dubious of that.
Well, I know that you paint the picture in the light most favorable to you and your client, especially during your argument. Do you do that on an affidavit where you swear under the pain and penalty of perjury?
Well, what about that? Because I mean, that is a different issue now, isn't it? So how far is too far?
When it becomes not truthful.
When it becomes not truthful. And what does that mean?
Like if you have a fact, I mean, there's only so many ways you can say it. If you know the floor was white, I mean, you could say other things that mean white, maybe that might lean more towards it, but you can't say it's black, and you can't say.
Well, let me ask you this. Let me ask you a concrete example. I'm not sure what color of the light was. I think it was green. In the affidavit, is it okay to put, I believe the light was green? So you left off the first half.
Yeah, because I believe it's. Wait, what was the first half?
The first half was, I'm not sure what the color of the light was. I believe it was green.
Well, then you're going to be impeached on cross. No, it's
Well,
not impeaching. You're not sure what it was.
I'm not going to be impeached on cross at all if there's no evidentiary hearing, right?
Saying I believe it was green is the same thing as saying I'm not sure. Instead of saying it was green.
You all agree to that, or? Well, because again, if I write the affidavit, I'm
Put in, you're not sure.
Huh?
If you put in, I'm not sure, that's more for the other side to go on.
Right.
Because now you've shown doubt right from the start.
So I believe it was green.
It's more of a concrete statement than, I'm not sure, I believe it was green.
So it's okay to, so it is okay to slant the facts slightly in that affidavit, right?
Yeah.
I don't think that's slanting a fact because the fact is you believe it was green.
But you left off kind of an important fact.
But you're not slanting it.
Well, aren't you slanting it by leaving out the part that he said he wasn't sure what the color of the light was?
No, because I think I believe.
Well, and that's okay. Listen, the only exercise is this, and I want to get to your other part of the answer as well, because it is one of my absolute dues. Listen, we do it, right? This is what we do. I was writing stuff today, and I look at a word and I change it, and I come back to it and say, no, I can make it a little stronger. I wasn't doing affidavits, but that's what we do as lawyers, right? We become advocates. We're supposed to. We're supposed to use the right word to convey the right image and sometimes feeling that we want the person to have. That's what we do. Irving Younger says that the lawyers are today's warriors, and words are our weapons, right? And I think that's true. So we use those words carefully. That's why you're spending all this time in school. So I get to write the affidavit then. Well, I'm going to put it in the light most favorable that the client will agree to, right? Or that the person signing the affidavit will agree to. Agreed? And now listen, how do we make sure that it becomes their words and not ours, or their acknowledgement that it's the truth? I have followed this consistently throughout, and there will be people, including people in this building, who will try to avoid that. No matter what, I have always, for 25 years now, I have given them the affidavit, I have put them in a conference room or my room and left, okay? And they say, and I've heard this too many times, Mike, if you wrote it, it must be right. And I say, no, that's not the way this works. I want you to sit down, I want you to read it, I want you to make sure it's entirely truthful. And if there need, any changes need to be made, we will make them. But look it over very carefully and make sure it's accurate. And if it is accurate, then I'll have you sign it. But if it isn't accurate, we'll talk about what changes you want making, we'll make them. And listen, this is what happens too sometimes. They say, well, it's late, Mike, I got a rush, or I know you've got a rush, or whatever. This is the point where you need to slow it all down, okay? Because there's always a reason why they don't want to, why they can't take the time to do what's necessary and what's right. But this is one of the things you've got to be careful about, because when, if the stuff hits the fan, they're going to say, he or she didn't give me time to read it, he or she didn't tell me to check it over, it was truthful, I only looked at it and signed it and right in front of him. No, right? So that's the whole type of the process where you've got to slow it down and recognize that no, if there's problems with it, I'll fix it. Because I've already told you that there are problems with the process itself. You wrote it, right? Because oftentimes what that'll start with is, well, you send me a narrative of the facts and I'm going to put it in affidavit form, right? So it is, you wrote it, right? You wrote it at the end of the day. And that, on cross-examination, that's a legitimate question. You know, deposition. Who wrote the affidavit? You didn't write that, did you? No, who wrote it? He did. Your attorney. Now you're sitting across the table. And I'm going to go into that. And I'm going to go into the process for it. You want to make sure that has been carefully attended to, and you followed your established procedure, so there can be no doubt that this time that procedure didn't vary. That is one of those things, by the way, that I really think I honestly God, I have not varied that procedure ever. Or the only variation is I will send them the affidavit. They have even more time to look it over. Edit it, make whatever changes, send it back to me. We'll then get ready to finalize it with your edits and changes. And so then they still come in and they read it over. But that's the only thing that's changed. Sometimes they have even more time to look it over. And you need to do that.
Do you make them sign a document saying that they have in fact read it? I mean, aside from what goes on in the affidavit, that they acknowledge that they've read it and any changes that they've...
No, but by signing it, that in essence is what they're doing, is they're saying that. And I know that I always follow the same procedure when that's done, so I have no problem that that's precisely the way it went down. And that's why it's important for you guys to recognize that. First person under the bus is you, right? First person, you're not family, you're not a friend, you're no one. You're a guy I pay, or a woman I pay a lot of money to get this right. And so when it goes bad, and that's why you want to make sure that you're careful about how you do it. Here, especially in cases like this, because this I live for this, right? So now I put you on the stand with proposing the injunction, and you don't hold up to your affidavit at all. No, really, right? This is it. So precisely what I was hoping was this little piece I could blow up into be huge. You won't stand behind, that person won't stand behind the affidavit, and not just stand behind, now, because think about it, right? We're in court, sometimes federal court, it's imposing, and now you've been sworn, and this is no screwing around anymore, you're not just signing paper. And you've got the imposing figure up on the bench, and now, if I get you to walk from any of those, then I've got a chance to win this, because it puts into doubt that credibility issue that we talked about. That's why, again, this is one of these areas, you dot your I's and cross your T's and make sure it's right. That's the other reason why you don't go too far. You go too far, and you've exposed yourself, right? That's the other part of it. It's not only the person who signed the affidavit who looks bad, the lawyer looks bad. The person seeking the injunctive relief looks bad. And we're going to see a case, I don't think it's tonight, I think it's next week, where, you know, once the court disbelieves your client and disbelieves you, you are done. Right? There's no reason to give some slimy lawyer and his slimy client anything. And that's the way this works. But that's the way, so here, they wanted the evidentiary hearing. Campbell's never said that the facts were in sharp factual dispute, and therefore, they're out of luck. No evidentiary hearing, and they don't get anything else. They can wait, but by the time this case ever gets reached at this point, soup season is over. There is no trade secret anymore because everyone knows about it. This case is over as of the time of this hearing being won. And Campbell's knows it. That's why they tried to take their appeal. A couple of other things just to think about with this case. They talked about this Ayoud case, which is going to be next week. And they talked about Rule 65 fact-finding. Preliminary injunctions, when the court makes some findings at that point, they really are statements as to probable outcomes because we haven't had a trial. The problem with it is, it's like a lot of things in life. Once we make a decision on something, we don't tend to reverse that decision. We tend to look for support as we go as to why that was right. So that's why winning on the preliminary injunction becomes very, very important. Campbell sought impoundment of the papers. We haven't talked about that before either. But there will be cases where the other side will want you to agree to impoundment. There will be cases where the other side will want you to agree to confidentiality provisions with respect to the discovery information in the cases. That's up to you. I don't always think it's, well, first of all, the preference is, under the First Amendment, that papers not be impounded and that information not be seen as confidential. So first of all, it should truly be confidential, proprietary business secrets if we're talking about that. And I've had cases where we've entered into those agreements. I've had other cases where I've refused to enter into such agreements because I don't think the papers are confidential. I think the information is embarrassing to the company. They would like to keep it secret and hidden, but that doesn't mean it should be impounded. The fact is, the fact that it is embarrassing and that they shouldn't have done it in the first place may well be a reason why they should settle sooner rather than later. And if they can keep it secret and keep it hidden, that doesn't necessarily advance my interest. And there will be times where you have cases that will gather some public interest, and the fact is you don't necessarily have to agree to keep that all secret and hidden because I'm not sure it's in your client's interest, and it's certainly not the public's interest when you've got companies that potentially there are not just these employees but others who are suffering from similar issues. Republic of the Philippines versus New York Land Company. Here they sought appointment of a receiver to manage and control the buildings. And it talked about a receiver as being an extraordinary remedy. And you should know what a receiver is. A receiver will take control over the corporation and has the full power to do whatever they are charged with, including potentially the liquidation of the entity that they are appointed the receiver of here. In this case, there really is to try and manage these large commercial properties while the litigation is ongoing. And so there's a whole bunch happening in this case that you should take a look at. I mean, we've got, again, declaratory relief in places. We've got an intervention as of right. What gives someone the right to intervene as of right in someone else's case? What's an intervener? And yes, some of you have studied this. So what's an intervener? What's the rule number? Maybe that's where we study.
I think it's similar interest.
What do you think it is?
Someone who has similar interests that they need to be a part of the case.
That's pretty close. Similar interest?
Or the same interest.
Is that what you said?
Yeah.
A stakeholder.
Stakeholder? That language sounds familiar, right? And that all of that is somewhat familiar. Interventions found under Rule 24. And what it really does say is that you have an interest in the case, that you're so situated that as a practical matter, or you have an interest in the case, no one presently in that case represents your interest, and that as a practical matter, the resolution of this case may impair or impede your ability to protect that interest. In essence, you are a stakeholder in the outcome, although you're not presently there. And there's two different interventions. Intervention as a right, which means you must be allowed to intervene, as opposed to permissive intervention, which means the court may allow you to intervene. So here we had the intervener come in as well and attempt to have this case, have the receiver appointed. The language on 36 and 37, there's a lot of important language for you to start to think about there. It talks about the appointment of a receiver as an extraordinary remedy, and it is. And what it allows that receiver to do is anything he or she chooses to do with that corporation that the court orders. You know, sometimes we see, I think the Boston Housing Authority had been in receivership. I don't know whether it was a master or a receiver that the court appointed to help clean up Boston Harbor, but usually they are major public issues. But they also can be corporations that need to be managed either because creditors seek to have them managed that way, or that they haven't complied with the orders of the court. And in this case, what they're worried about is during the litigation, the assets could be lost because they're not being managed properly. And so the language in the case talks about that equity should have flexibility, as is traditional here, to try and decide what would be appropriate under the circumstances. And there is a great deal of latitude in determining whether equitable remedies should be issued. Here they talked about the evidentiary hearing, and that's why it's here as well. So now we've got what appears to be a mess of a case, and the appellants are claiming, well, we should have had some form of evidentiary hearing before this extraordinary remedy was issued. And if you look at the language on 37, bottom and carryover column, what it talks about is, first of all, they never asked for one. And if you want something, you need to ask for it. If you want an evidentiary hearing, you should ask for it. Not having asked for it, don't complain you didn't get it. So that's the first thing. Have some backbone and stand up and tell the court you want that evidentiary hearing. And then this is Second Circuit now, so this is New York. Well, what this says is language similar that we saw and we pulled out of the other case. Where essential facts are in dispute, there must be a hearing, and appropriate findings of fact must be made. And then it goes on to say, it is not a rigid requirement that oral testimony be taken on a motion for a preliminary injunction. Not a rigid requirement. But as you can see here, where essential facts are in dispute, the preference is that they do so. And then they talk about the failure to make those findings of fact that we led the class off with, and rulings of law that are required under 65D, since the request for injunctive relief is a jury-waived issue. And what they say here is, yes, the court should do it, and it gives you a little rationale. The purpose of these rules is twofold: to aid the trial court by requiring it to marshal the evidence before it, and more importantly, to aid us in our review. Think about it, right? It's not just, I grant or deny injunctive relief. What are the reasons supporting it? And so that's why those findings of fact are important to do. You know, one more to do before you get out of here, and that's the Great American Chocolate Chip Company. And this is out in Chicago. And the Cookie Company and the Seagulls are having a dispute about the proper operation of the franchise. And this case was, at least initially, referred to a magistrate judge. In federal court, quite often, our federal judges work with a magistrate judge, and that magistrate judge, if you agree, can hear some of the matters pertaining to the case. And that's what happened here. The magistrate judge recommended that the district court judge grant the Siegel's motion for a PI, and then the district court judge did so. And if you look at the report and recommendation, there is some type of order, but it's not an order consistent with what the court feels is sufficient. Why were they trying to prevent the Siegels from operating the franchise? I mean, it seems a little heavy-handed, no? Were there sins that egregious? Geneva says, yep. Yeah, tough nut. Because Mr. Siegel, the grandfather's going to lose everything here, isn't he? What were the sins that were that egregious that they should be stripped of their franchise? Go ahead.
Really bad management, and then they.
When you say what that categorized, what's bad management? It's a little gum under the counter?
A little, well, they weren't, it just said that the manager was incompetent. He didn't pretty much know he was going and everything.
But the manager is the Siegels, right? The other franchise,
No, they weren't, it wasn't, they were,
the other one the Siegels ran there was no problems with, right?
right.
But this store, they had problems.
Yeah, but
And
they
it was the
were
person
like
in
never
charge.
there.
Okay, so they were an absentee
Oh.
owner. But so, okay, so come on, what else you got?
Okay, so they failed to furnish insurance certificates, so they didn't have insurance. Their checks bounced if they paid, and sometimes they paid late. They flunked a lot of inspections, which I think is pretty big for a food company. Yeah, oozing cheesecake, undercooked, and misshapen.
Oozing cheesecake. Does that really sound that bad?
It sounds disgusting.
What if it's chocolate?
Brownies,
Ooze?
runny brownies.
What, runny brownies?
Yeah, chewing gum stuck to counters, improperly dressed employees, underreported sales, so they were.
So that's a big one too?
Yeah,
Cheating?
they weren't giving them
Cheating
royalties.
financially, underreporting sales, giving us checks that bounce,
Keeping an unsanitary.
unsanitary food establishment, so it hurts the franchise company as well. So you guys all think this is pretty serious stuff? Serious enough that you're going to take Mr. Siegel's, Mrs. Siegel's father's house and his retirement fund? No, you are, right?
He's taking a lot of money, though. I mean,
Well, he is, or he just happened to put up all his retirement and his houses to help out his daughter.
Right, you shouldn't have done that.
And he shouldn't have done that. And now he's going to lose everything.
Yeah.
And that's just tough luck.
She owes him big time.
Well, they
Go ahead.
did it to themselves. I mean, after they were told that they were not supposed to continue under their trademark, they kept doing it anyways. And then on top of that, they cheated when they were underreporting their sales. So if they didn't do these bad acts ahead of time, then maybe I would feel bad about them losing everything. But they, instead of looking for the appropriate remedy at the appropriate time, they did the dishonest thing and they violated their
So they
contract.
waited until they
and
got caught.
They waited until they got caught.
Yeah.
And so none of you would have a problem with this? I mean, taking old man Mr. Siegel's retirement and
well, you
house?
might be able to work out some kind of a settlement, but what's their real goal? It isn't getting the money that's owed to them so much as.
Well, but it sounds like the defendant sort of rejected that notion,
Yeah.
right? They did offer them,
Well,
they
they
did
were-
offer them an out here, and they
Right.
said, no.
So that now you can't really feel bad for them when you offer them the out, you know? I mean,
Still not gonna feel bad that you've taken everything the innocent party had here?
They're not
They're
innocent
not
though.
innocent.
They're dishonest and they.
No, I'm not talking about Mr. and Mrs. Siegel, or their manager, or their employees. I'm talking about Grandpa.
No.
No, well.
No.
Not.
No, seriously? I mean, listen, I hope so, because I think you have a job to do here. Huh?
I'm gonna feel bad, but I'm gonna do it anyway.
That's Siegel's problem.
Is it Siegel's problem? Because you're the one giving him the bum's rush and taking his retirement and his house. And, you don't see it that way. It's
You
not,
stuck it on
huh?
You put it up there for
Put it up there for them. You invested in them. It was a bad investment.
Agreed, but you're the last man standing who can fix this, but it's not your job to fix.
How do you fix that? I mean,
We're supposed to say,
Well, I
thanks
don't-
for screwing me for years, here's your retirement, your house.
Well, you just said you would feel bad about this.
I would feel bad, but I'm still gonna do it.
It's
Well,
like the
okay,
popular
okay, well, no, but
restaurant, you know?
okay, but let me ask about that, because that's what I'm wondering. Listen, I feel bad, but I'm not saying that I wouldn't have to do it either. I'm just wondering whether you guys are being realistic to say, no, I wouldn't feel bad. Because you see some old man crying.
Well, yeah.
No, right? Because
Personally,
Like, you know, I'll use an analogy. When a police officer arrests
Yeah.
a drunk driver and he says, I'm gonna lose my job.
I'm gonna lose everything,
I'm
right?
gonna lose, and you know those are some of the, and there's even more possible ramifications, you know.
And you can't let them go.
Yeah, I mean, do you feel good about it? No, not, I mean, but.
Suppose it wasn't a DUI. Suppose it wasn't DUI, Freddie, but he had the knife that that he had a knife that was concealed and it shouldn't have been concealed, and he starts bawling his eyes out, telling he's going to lose everything. It's a violation, but
There's always discretion involved in.
yes, there is, isn't it?
No,
No, but
you can let some people go that you, same.
but so can you.
Same situation where
No,
you're,
I
no,
don't-
not when you're advocating for a client.
Yeah.
Well, can't you go back to them and say, listen, this is just not, you really want to do this, or no? I mean, listen, I'm not the town priest. They made bad decisions, lots of bad decisions. And it's not my job to represent him. He should have had a better lawyer. By the way, that happens too, right? So
Right.
you face a real bum on the other side, and you're again, that's not up to me to represent both sides in the case. But I do recognize that a better lawyer would make better arguments, and these poor people wouldn't. And it's worse when they pay a lot of money for bad lawyering and bad advice, and you know what's going down. But it's not my job to level the playing field either. But I recognize that. But I'm still going to feel bad, no? Or because
Well,
that's
you
what I
know,
wonder.
you
You
know-
guys think in the abstract that you're very easily going to separate out lawyer Geneva from person Geneva, and is that likely? No, and listen, I hope you can, because there's sometimes we're required to do lousy things. We are, aren't we? And especially like this, where, okay, listen, I'm giving you a bunch of opportunities to get out, to stop, right? They did actually say, just tend to the store back, didn't they? And we'll move on. And they said, no, no, no. So, I mean, that's why certainly it is a lot easier to say, for God's sakes, you could have got out so much more cheaply, so many other places here. You made your bed, but I'm still a guy that's like the match to that bed at the end. And you are, right? John?
I was going to say, you can sometimes these things can backfire, and the local newspaper can pick up the story, and it can end up looking bad. So if you're representing a corporate client, you could tell them, this could be bad for business for you.
Yeah, but go ahead. You going to respond to
I
that?
was just saying, if I were the company, my argument would be that this already looks bad for us.
Yeah,
This is a
right. I think this is one of these where, okay, yes, we're going to look like
Sure,
crumbs.
maybe,
To use a good.
Yeah.
But if people hear that the franchise was unsanitary,
Yeah.
and
Food was
just
bad.
thank God no one got really sick,
And that the
that
higher-
doesn't flatter us either.
Right.
And that gives you, the circumstances are going to define the whole thing. There's one example. The other one you mentioned before, if you've got a bad attorney on the other side, I mean, if this playing field really isn't level and you're beating these people up 6 ways to Sunday, then you want to kind of put the brakes on a little bit somehow. So, yeah, you maybe want to talk to your client about something like that. I don't see that here, and what I'm looking at in this case. It's just like when you have little kids playing ball games and one team's beating the hell out of the other one.
But there's a mercy
Coaches
rule.
did it. Well, yeah, well, exactly.
Well, here there's no mercy. You're going to
make your own
you're taking Grandpa's retirement and his house.
You make your own mercy rule. I don't, that standing by itself doesn't mean anything to me. As far as I'm concerned, you pledged it.
Oh my God, you
That
got
was
some
the deal.
80-year-old man crying, bawling in front of you because you're taking his retirement and house, and you really think that's going to be a good night? You better have a lot of whiskey.
You don't have to trade in your humanity to have Esquire after your name.
Yeah, but
No, not too
but
much.
I'm not sure you have to. I'm not sure you have to do any less on this. But I'm just you may be, and I do think you owe your client the obligation. We tried, but at the end of the day, he loses everything. and you're okay, not okay with that, that's what I've got to do. I just wonder whether, when the rubber hits the road, that's as easy to do as we could sit here in a classroom and say, no, I can do that too, right? I mean, some of you will work for DSS, right? Some of you will work at taking people's children away from them. Now, maybe the worst of them deserve that. But, you know, it's going to be a lot of the ones that are a little closer, right? A lot closer. And I was worried about those cases where, okay, so you're going to take them away from the parent that can, and now you're going to split up the brothers and sisters? Because I have 3 brothers and a sister. And my sister you could have, but no, she's okay. But one last thing. Where is it? It says here, if you look at the language, and it's 280 and 281, and this is what we are, right? We're lawyers. It says contract law does not require parties to behave altruistically toward each other. Neither does it in our profession. It does not proceed on the philosophy that I am my brother's keeper. It doesn't. We're required to do some tough things sometimes. It's not necessarily easy, but again, we have our roles in the system, and you just have to figure out, well, where does your role as a lawyer end in, as Melanie put, your humanity end? All right, can they hopefully travel some path to it? But it sounds like, based on all of you, Mr. Siegel's living out of a cardboard box today. Right? Well, bad choices. And I'll tell you, in a lot of litigation, that's what we see. Really bad choices by people that there were, you keep making bad choices, we're going to have really bad results. And that's unfortunately what happens in a lot of cases, is and that's why I think it's important for you guys to think early on. Well, how can we really get them to think earlier on before we're 50 or 100,000 in and now there may be no turning back? Are there ways that we can resolve it that at least more people will think that they've been somewhat successful? And I think that case was a good example of, God knows, the plaintiff's lawyers look like they tried, and the defendant's lawyers, defendants themselves, look like they were just blind to what is the ultimate likely result. And that's too bad. That's too bad.
It's no different than like a divorce case, and you suggest that they maybe try and work out some details, but they want to fight over and they end up paying each attorney $100 grand, and you just walk away shaking your head because no one wins.
Absolutely.
Right?
Oh, well, that,
This
and
one
we
you
do
walk
a section
away
on that where it talks about,
You walk away
again,
from it shaking your head going, can't believe they didn't take the other alternatives we offered. What else
It
are
cost
you
me
gonna do?
$2 grand.
That sucks. We just did a divorce where we had sent a settlement offer probably about, I don't know, 13 or 14 months ago. And then $28,000 or $29,000 later, they ended up agreeing to exactly what we had suggested back then.
Thank you.